Yes. May please, Your Lordship. Your Lordship, I beg to mention item number 3, Your Lordship. Actually, Your Lordship, I was asked to furnish certain documents. I have just received those documents, Your Lordship. Your Lordship, just for today, Your Lordship, the matter will be listed immediately after vacation, Your Lordship. Yes. All right.
May please, Your Lordship, I beg to mention item number 37, my lord. Kindly come after vacation, my lord. I'm supposed to file affidavit in opposition. I have already informed the petitioner also, my lord, and respondent, private respondent also.
Like that may be fixed, madam.
We're not fixing any date, Mr. Sharma, at this date.
38th of January.
We're not fixing any date at this moment. We'll just adjourn for a week.
And
My lordship, I beg to mention item number 23, my lordship. I may be allowed to go through the lower case record, my lord. Item 23.
In presence of the Trust Standing Council, Home Department, you can go through.
may please, Your Lordship, in item number 33, my lord, I have filed an affidavit in opposition today morning only. That may be called for, my lord. Much better.
Wait, please, Your Lordship, I beg to mention item number 3 of the day release.
Three just been mentioned.
Just two, Lordship. Two, Lordship, this matter we adjourn for the day, Your Lordship.
That matter was taken up that day.
Lordship, we are supposed to file an additional affidavit, Lordship. It is ready, Lordship.
For 10 days, corridor thereafter.
Another prayer, Lordship, is item number 16, Lordship. His brother case on fixed on 12/1, Lordship. So that matter may be tagged to along with this matter, Lordship, on 12, Lordship.
Read petition number.
Rate petition number 3/24, Lordship.
Only 3.
Yes, Lordship.
03.
03, Lordship.
Along with WPC number 03/23.
Deeply obey, Lordship.
It mentioned item 24, lordship. Kindly pass out the matter for that day, lordship. 24.
May please, Your Lordship, I beg to mention item number 30. Kindly pass over the matter for the day.
For a day.
My lord, I would beg to
Only date
mention,
to be fixed for the day. I'll go through on a day.
my lord, I beg to mention item 10, my lord. Today, my lord, we were supposed to get the instructions, my lord. But may I pray, my lord, that it may be listed immediately after Bihu vacation, my lord. I have not received.
After 10 days, on a date to be fixed for the register on the prayer of Mr. G. Gupta, right?
H.
H.
Gupta, my lord.
Lawrence is this for the petition.
May I please, your lordship. I beg to mention item number 4, lordship. This matter may be adjourned for today, lordship.
On a date to be fixed for the
Your lordship, I beg to mention item number 27 from the daily cause list. The matter may be kindly be enjoyed for the day as my senior has medical emergency.
Therefore, it must be first. On a date to be fixed. Yes.
Hello, please.
May I please, Your Lordship, as per order dated 26/5/23, Lordship, the Honorable Court directed us to file our additional affidavit. Study, we filed our additional affidavit. So kindly matter may be come upon vacation, Lordship, along with the affidavit, Lordship.
Or MS A. Begum, counsel appearing for the petition. MS A. Verma, Learned Standing Counsel, Home Department, Assam, for the 2 and 9. Anyone for the election committee? Mr. Kuli, you were there? Mr. Kuli, Standing Counsel, Election Committee. For the respondent numbers 3 and 4. The A. Verma, 8 and 9. 2, 8. And Mr. Kuli, you will also appear for respondent number 6. Foreigners Regional Registration Authority, or it will be by the Home Department. Ms. Verma, respondent number 6.
No, Lordship.
P. Sharma, 7. The learned member Fairness Tribunal, Part Nagaon. In FP case number 206/2016. Corresponding to IM within bracket T, case number 816/2000. In a reference being made by the Superintendent of Police order Nagaon. After hearing the parties. In a reference being made by the Superintendent of Police order Nagaon. After hearing the party and considering the evidence used by petitioner by the impugned order of the opinion dated 31/08/2020, declared her to be a foreigner under the foreign law 6. Foreigner of illegal migrant of post 25/03/1971 street. Agreed by said opinion of the landed member for next tribunal dated 31/08/2020. The petitioner filed this petition on 22/05/2023. After about 2 years in Pakistan. Two years. 2 years. Is a notice returnable by 8 weeks. Yes, something doesn't. Petitioner shall be by tomorrow. Okay. Petitioner shall submit to the director of appeals. To the architect of the land. Application is for the by tomorrow. Application. Petitioner shall take step for the notice of the respondent of 5, 6. By registered tomorrow. Subject to taking step from the respondent direct to them. And if in the meanwhile, she hasn't been taken into custody, pursuant to the impugn opinion dated 31 February 2020, on her appearance before the Superintendent of Police Court at Nagaon on or before 29/01/2022. Only, right. Okay. Will be released on bail. Call for the call for the records of application number 206 of 2016 from the office of the Learned Member of Finance Tribunal Department. That was 20. This matter for immediate notice. On the returnable date, petitioner shall apprise the court as to when she appeared before the superintendent. This all.
Lordship, item two, which has just been mentioned, Lordship. In this matter, on the last date also, it was adjourned. The government has filed affidavit because there's a complete mismatch of the land documents. That affidavit is also on record. Lordship may fix a date for item two. My friend just mentioned, but I missed out the matter, Lordship. May fix a date and take it up, and the LCR may be called for, Lordship. There is no order for the petitioner to file an affidavit like he submitted before the court.
So he is not appearing for two.
No, I'm making that mention because Lordship,
Not because in the absence of the counsel for the petitioner, we are not.
Lordship, he mentioned it so fast, there were so many items, I missed it out.
List on Friday. 12.
12.
Second. Second.
Mhm.
Yes, okay. Okay. Me deal with this one. Order to my river for okay. No, please. This matter is against the impugned judgment and order dated 28/7/2023 passed by the Foreigners Tribunal for Consular. Judgment is there, starts from page 74. And my lord, 83 is the last page of the relevant portion, my lord. Where is this stated, my lord? There is no linkage found with the maternal grandfather. My lord. Now, my lord, lordship may kindly come to page 17. 17. Just a minute. Please take your seat, Mr. Chaudhary.
Yes.
Pardon, Mr. S. Chaudhary, counsel appearing for the petition. And Mr. H. Tahu. And MS Evama, standing counsel home department Assam for the response number 3, 6. Also heard. Mr. P. Sharma, residential of Assam for the response number 5. No representation on behalf of the Union of India as the number 1, the election. The petitioner was considered as a doubtful voter and a reference was made against her by police reference case number T oblique 6933 oblique 99. Accordingly, Foreigners Tribunal's case number 622 oblique 2009 was registered at the Foreigners Tribunal 1 Karimganj, which was later transferred to Foreigners Tribunal 3rd Karimganj, wherein it was registered as FT case number 690 oblique 2017. Learned member, Foreigners Tribunal 3rd Karimganj. By the impugn order dated 28/07/2023. After hearing the party, considering the evidence adduced by the petitioner by the impugn order dated the such. Point. The petitioner to be a foreigner under the Foreigners Act 1946. Foreigner of 25/03/1971 stream under the Foreigners Act 1946, as well as the Citizenship Act of 1955. They satisfied the opinion dated 28/07/2023. Passed by the learned member, Foreigners Tribunal 3rd Karimganj noted above. The petitioner has filed his petition on 13/10/2023. Notice returnable with the Friday. 8 weeks. And such and such. No formal notice. Petitioner shall take steps by tomorrow for clearing his. Petitioner shall serve requisite copy of extra paper this application to Mr. R.K. Dev Chaudhary, standing from, Planet Deputy SGI. For the respondent in New India, for New India respondent number 1. Mr. A.I. Ali, standing council election commissioner with for the respondent of necessary action. By tomorrow, correlated by that. Petitioner shall take steps for service of notice on the respondent number 4 by registered post secretary by tomorrow. Subject to taking steps on the respondents as directed above. And if in the meanwhile, she has not been taken into custody pursuant to the impugn order dated 28/07/2023 passed by learned member, Foreigners Tribunal 3rd Karimganj in FT case number 690/2017. Subject to her appearance before the Superintendent of Police Border Karimganj on or before 29/01/2024 along with a certified copy of this order. Back in bracket. All for the records to place this matter for admission immediately on the civil relevant records from the concerned Foreigners Tribunal.
May I please, Your Lordship. Lordship, here the impugn order starts from page 15, Lordship. Petitioner, Lordship, was declared a foreigner of the stream, Lordship, 1166 to 25/3/17, that period, and she registered herself, Lordship, by, and subsequently again another proceeding was there, Lordship, and where she was declared as an illegal migrant of the post 25/3/71 stream, Lordship. Applied for registration difference. Exactly, I can say that there is one number is here. 43. One registration number is there. Yes.
Heard Mr. M. Ahmed, counsel appearing for the petitioner. And MS Livermore, standing counsel from Department Assam for test number 2 and 6. Also heard Mr. P. Sharma, additional senior governor of Assam for the respondent number 5. Kuli is here. And Mr. H. Kuli. Agatul. Standing counsel election for the respondent. In a reference being made by the Superintendent of Police Bota Torong under date and I am in the Kitty Petulski Act 1983. The learned member of Fairness Tribunal Court Torong Mongoldoy in FT fourth case number 233 oblique SPR oblique 2017 by the impugn opinion dated 30/03/2019. Impugn order. After hearing the petitioner and considering the evidence adduced by her, declare her to be a foreigner, the Foreigners Act 1946, who had illegally entered into territory of India within Wicked Assam after the cutoff date of 25/03/1971 stream. Agreed by the state of in order dated 30/03/2019. The petitioner filed its writ petition on 25/10/2023. After more than 4 years, 7 months. Petitioner contended that in a similar proceeding against her, in FT within bracket D case number 8216/2012, arising out of SP within bracket B case number 780/1998. The Foreigners Tribunal Tezpur First District Sonitpur by an opinion dated 1909/2016 considered her to be a foreigner and doubtful voter coming to Assam illegally from the specified territory during the period between 01/01/1966 to 25/03/1971. It is submitted on behalf of the petitioner that the learned Foreigners Tribunal, Court Dorong, while passing the impugn order dated 30/03/2019, did not consider all these aspects in proper perspective and rejected her contention. Is a notice returnable by 8 weeks. However, maintainability of this writ petition is kept open considering the fact that the petitioner against the order dated 30/03/2019 of the Foreigners Tribunal, Port Dorong, Mongoldoi, papered his petition on 25/10/2023. Regarding the delay, mental and the delay has kept open and shall be considered next at the time of its admission stage. Steps right. If not arrested pursuant to the order dated 30/03/2019 by the member of Foreigners Tribunal, Port Dorong, Mongoldoi, in FT Port case number 233/SPR/2017. If we have steps according shall be released. call for the records of such and such, and also the records of FT within bracket D case number 8216 of 2012 arising out of SPB case number B border, no? Case number 780 of 1998 from the office of the Foreigners Tribunal Tezpur First District Sonitpur that was disposed of on 1909-2016.
Maybe, Your Lordship. So in this case, Lordship, it probably shows Lordship LCR is received in one case, Lordship, but LCR of both the cases were called for, Lordship. Whether it is received or Lordship, I am not confirmed. And two numbers of LCR are supposed to come, Lordship, in each case, Lordship. Received, Lordship. If this Lordship, then Lordship, let me tell you, I have to verify, Lordship. I have not gone through the earlier known Lordship. The point is on the residual Lordship. There is a earlier LCR Lordship. There is also not in my knowledge, Lordship.
You verify, we'll take it up at 2 o'clock.
Lordship, I'll try, Lordship, in the meantime.
Verify in presence of the council for the standing council home department. You verify.
Maybe can any other deal, Lordship. In the meantime, in short time, whether I can verify this all, Lordship.
Tomorrow,
Yes, Lordship.
tomorrow.
Lordship.
Petitioner paid for short accommodation allowing to verify the relevant records of the person for an efforts. That's the 5 minutes, sir. They are allowed. That's right. Counsel for the petitioner, Mr. S. Hawk. Paid for short accommodation. Where allowed, Mr. Hawk, parent counsel, shall verify the records of the council for a tribunal in presence of the standing councils, home department, and some during the course of list tomorrow. Or motion.
Please, your lordship. My lord, the opinion, my lord, rendered by the foreigner tribunal number 2 Lakhimpur, my lord, at page 43.
Please take your seat.
My lord, page 43. my lord. You can read vernacular? Yes, ma'am.
Come to page number 19.
It's my
Read your written statement.
বিচারপতি উক্ত গোচৰত অপৰপক্ষৰ লিখিত বৰ্ণনা এই যে এক অপৰপক্ষ এজন জন্মসূত্ৰে বৈধ ভাৰতীয় নাগৰিক হয়। অপৰপক্ষৰ জন্ম লখিমপুৰ জিলাৰ লালুক মৌজাৰ দৌলতপুৰ গাঁৱত হয়, বিদেশী বা সন্দেহযুক্ত নাগৰিক নহয়। অপৰপক্ষৰ ককাকৰ নাম মদন আকন হয়। তেওঁৰ নামত NRC ভোটাৰ ডিটেইলছ 1966 চনৰ লিগেচি আছে। ডাটা কোড গাঁও দৌলতপুৰ LSC নাওবৈচা। Exhibit 1 NRC voter list detail of 1966. অপৰপক্ষৰ পিতাৰ নাম সমৰ আলী আৰু তেওঁৰ নাম নাওবৈচা বিধানসভাৰ সমষ্টিৰ লালুক মৌজাৰ দৌলতপুৰ গাঁৱৰ 1965 চনৰ ভোটাৰ তালিকাত আছে। খণ্ড নম্বৰ 142, ঘৰ নম্বৰ 235, কমিক নম্বৰ 277।
No, all these are not required.
Yes.
That is sufficient.
Yes.
Come to 4.
অপৰপক্ষৰ ভোটাৰৰ বয়স হোৱাৰ পৰা স্থান পৰিৱৰ্তন ক্ৰমে ভোটদান কৰি অহা হৈছে। প্ৰমাণস্বৰূপে এক্সিবিট ক LSC নাওবৈচা ভিলেজ কোঁৱৰপুৰ 1993 ভোটাৰ লিষ্ট এণ্ড চাৰ্টিফাইড কপি। ভোটাৰ লিষ্ট 2014 ভিলেজ কোঁৱৰপুৰ চিৰিয়েল নম্বৰ 213। ভোটাৰ লিষ্ট 2016 ভিলেজ কোঁৱৰপুৰ চিৰিয়েল নম্বৰ 227। ভোটাৰ ID 2013 ভিলেজ কোঁৱৰপুৰ। অপৰপক্ষৰ ককা আৰু পিতা লালুক মৌজাৰ দৌলতপুৰ গাঁৱত আছিল, পৰৱৰ্তী সময়ত নাওবৈচা মৌজাৰ কোঁৱৰপুৰ গাঁৱলৈ আহি বসবাস কৰিছে। অপৰপক্ষৰ আৰ্থিক উপাৰ্জনৰ খাতিৰত কোঁৱৰপুৰ গাঁৱৰ পৰা পুত্ৰ পৰিবাৰলৈ লখিমপুৰ জিলাৰ কদম মৌজাৰ অন্তৰ্গত বাধাকৰা গাঁৱত মাটি বাৰী লৈ বসবাস কৰি থকা হৈছে। প্ৰমাণস্বৰূপে এক্সিবিট 4 গাঁওবুঢ়াৰ প্ৰমাণপত্ৰ, বাধাকৰা গাঁৱৰ খাজনা ৰচিদ। অপৰপক্ষ এজন জন্মসূত্ৰে বৈধ ভাৰতীয় নাগৰিক হোৱা স্বত্তেও এই গোচৰত হোৱাত আক্ষেপৰ কাৰণ।
Okay, fine. Now please come to your evidence at page Ross, page 26.
21 যি কম সঁচা কম মাইল।
That's
Exhibit
there.
1 নাওবৈচা বিধানসভা সমষ্টিৰ 1965 চনৰ ভোটাৰ তালিকাত স্বাক্ষৰিত নকলৰ প্ৰতিলিপি অস্পষ্ট। কমিক নম্বৰ 391 ভোটাৰৰ নাম সমৰ আলী, পিতা মদন, বয়স 39 বছৰ। ইয়াত ভোটাৰ সমৰ আলীক অপৰপক্ষৰ দেউতাক বুলি দেখুওৱা হৈছে। ইলেকশ্যন অফিচৰ চিলমোহৰ নাই বা চাৰ্টিফাইড টু বি ট্ৰু লিখা হোৱা নাই। এক্সিবিট 2 1971 চনৰ নাওবৈচা বিধানসভা সমষ্টিৰ ভোটাৰ তালিকাত স্বাক্ষৰিত নকলৰ প্ৰতিলিপি। ভোটাৰ নম্বৰ 277, ভোটাৰৰ নাম সমৰ আলী, পিতা মদন, বয়স 45 বছৰ। 1965 আৰু 71 দুয়োটা বছৰৰ সমৰ আলীক বয়স একেই, 45 বছৰ দেখুওৱা হৈছে। 1971 চনৰ পিছত সমৰ আলীৰ নাম থকা ভোটাৰ তালিকাত স্বাক্ষৰিত নকলৰ প্ৰতিলিপি দাখিল দিব পৰা নাই। অপৰপক্ষ মাকৰ নাম থকা ভোটাৰ তালিকা স্বাক্ষৰিত নকলৰ প্ৰতিলিপি কোনো এটা চনতে দাখিল দিয়া নাই। এক্সিবিট 3 1993 চনৰ 110 নম্বৰ নাওবৈচা বিধানসভা সমষ্টিৰ ভোটাৰ তালিকা স্বাক্ষৰিত নকলৰ প্ৰতিলিপি। ক্ৰমিক নম্বৰ 358 ভোটাৰৰ নাম আকবৰ আলী, পিতা চমৰ, বয়স 40 বছৰ, অপৰপক্ষৰ বয়স 40 বছৰ হোৱালৈ চাই 1993 চনৰ আগত তেওঁৰ নাম থকা ভোটাৰ তালিকা স্বাক্ষৰিত নকলৰ প্ৰতিলিপি দাখিল কৰিব পাৰিব লাগিছিল। এক্সিবিট 3ৰ বাহিৰে আকবৰ আলীৰ নামত কোনো চনৰে ভোটাৰ তালিকা স্বাক্ষৰিত নকলৰ প্ৰতিলিপি দাখিল দিব পৰা নাই। অপৰপক্ষ থকা বাসস্থান ঢকুৱাখানা বিধানসভা সমষ্টিৰ কোনো এখন ভোটাৰ তালিকা স্বাক্ষৰিত নকলৰ প্ৰতিলিপি আদালতত দাখিল কৰিব পৰা নাই। এক্সিবিট 4 গাঁওবুঢ়াৰ চাৰ্টিফিকেট মতে অপৰপক্ষ পৰিয়াল ঢকুৱাখানা সমষ্টিৰ মাজগাঁৱত আছে বুলি প্ৰধান। কোঁৱৰপুৰ গাঁৱৰ নাওবৈচা বিধানসভা সমষ্টিৰ লাট গাঁওবুঢ়াই যি চাৰ্টিফিকেট উল্লেখ কৰা মতে সমৰ আলীৰ পৰিয়াল সেই গাঁৱৰ বসবাস নকৰে। অপৰপক্ষে ঢকুৱাখানা স্থায়ী বাসিন্দা বুলি প্ৰমাণ পত্ৰ দাখিল কৰিব পৰা নাই। এক্সিবিট 5 অপৰপক্ষ ভোটাৰ পৰিচয় পত্ৰৰ নাম উল্লেখ আছে। আকবৰ আলী, সম্পৰ্কীয় ব্যক্তি চমৰ আলী, গাঁও কোঁৱৰপুৰ, থানা লালুক, 1913 চনৰ, বয়স 58 বছৰ। এই কোঁৱৰপুৰ গাঁৱত অপৰপক্ষ বাসিন্দা নহয় বুলি গাঁওবুঢ়াৰ প্ৰমাণ প্ৰকাশ। অপৰপক্ষই ঢকুৱাখানা বিধানসভা সমষ্টি আজিলৈকে ভোটদান কৰি পোৱা নাই। অপৰপক্ষ ঢকুৱাখানা বিধানসভা সমষ্টিৰ অন্তৰ্গত হিচাপে থকাৰ কোনো প্ৰমাণ নাই। অপৰপক্ষৰ নিজা ঘৰ মাটি বাকী থকাৰ প্ৰমাণ নাই। অসমত থকাৰ প্ৰমাণ স্থায়ী বাসিন্দা হিচাপে অপৰপক্ষই দিব পৰা নাই। মাত্ৰ 1993 চনতে ভোটদান কৰিছে 40 বছৰ বয়সত। মোৰ জন্মৰ প্ৰমাণপত্ৰ নাই। মোৰ বাবাৰো জন্মৰ প্ৰমাণপত্ৰ নাই। মোৰ স্কুলীয়া শিক্ষা নাই। মোৰ ভনী এটা আছে, ভাই দুটা আছিল, ঢুকাল। মোৰ দেউতাৰ ককাই ভাই সকলো ঢুকাল। তেওঁলোকৰ পৰিয়াল বৰ্তমান নাওবৈচাৰ কোঁৱৰপুৰৰ গাঁৱত থাকে বুলি জানো। আমাৰ পূৰ্বপুৰুষসকল দৌলতপুৰৰ পৰা আহিছে, ভালকৈ মই নাজানো। অপৰপক্ষ দেউতাকৰ মাটিত হাল বাই খেতি বাতি কৰিছিল।
So how you have proved your linkage
My lord, that my
in cross examination? You have revealed everything what is there.
yes, my
How you
lord.
have proved?
Yes, that's correct, my lord. Your lordship will see, my lord, the language of the cross examination, my lord, and the person is a illiterate, my lord.
That it cannot be a summary. You have to see whether the order of the tribunal is bad or not. Now, this is your own submit.
Yes,
Accepting the voter list of 1993, you do not have any other list. You have not put any vote prior to 1993.
yes,
And in the voter list of 1993, you have been shown to be a age of 40 years. It has also been shown that you have not cast vote from anything from ঢকুৱাখানা Legislative Assembly constituency. Now the certificates that you have annexed the village settlement, you don't belong to that particular village.
yes, my lord.
So
My lord,
how you have proved your linkage with your father Summer? How you have proved that?
my lord,
Which is the link document?
yes, ma'am. My lord, earlier, my lord, they belongs to one place, my lord, Daulat.
That's different.
Yes, ma'am.
How you have proved your link document?
Only document that, my lord, identity, that voter ID card, my where, my lord,
Is it you have been doing many such cases? Voter identity card is a sufficient document to prove your linkage with your father?
and my lord, that voter list of 1993 and subsequent, my lord, two voter list, which is the, my lord,
Since you are of 43, what happened prior to 1993?
that is not available, my lord, in the record.
So,
And the LCR may be called for.
no, LCR call will be, but where is your status? to
Yes,
show
ma'am.
that? You will have a respite for few days, right?
Yes.
But how will you prove it?
Well, I'll, my lord, take instruction, my lord, whether there is any, my lord, further document, my lord,
That
then,
will be exhibited. Now we cannot look into the evidence, even if you bring final affidavit. How will you consider? We are not here to consider any fresh evidence. You are aware, in writ petition, we cannot do that.
that's correct, my lord.
Mr. Sarkar, what will you do? Yes. Ms. Verma? Or small, a little bridge till Bihu,
Yes, Lordship can do that.
that can
Some Bihu bonus.
hard listed. And Sarkar Council appearing for the petitioner. And Mr. H. Sahu. H. Kuli, sorry. Standing Council Election Commission in India for the election. Also heard M.S.A. Verma, Standing Council from Department of Sound for the 3, 6 and 7. As well as Mr. P. Sharma, additional government of Sound for the 5. In a reference being made by the Superintendent of Police, Lakhimpur, not Lakhimpur. Learned member of Foreigners Tribunal, that's capital 1. Lakhimpur, not Lakhimpur. In Lakhimpur, FP, that's capital 1, 2, in the E, capital D. Case number 153 of 2008. But the impugned final order dated 28/02/2020. Final order of declared the petitioner to be a foreigner under the Foreigners Act 1946, where they legally entered into the territory of India within Bekat Assam from the specified territory of Bangladesh on or after 25/03/1970. Dissatisfied with the said impugned opinion dated 28/02/2020. Petitioner filed this writ petition after more than 2 years, 8 months. Call for the records of, before we proceed further. We are of the opinion. Before we proceed further, we like to peruse the records of the Lakhimpur FT Desk Capital Roman 2 in bracket T case number 153 of 2008. Call for the record. That's it. Call for the record. Okay. In the meanwhile, if pursuant to the impugned opinion / final order at the 28/02/2020 of the learned member of Foreigners Tribunal to Lakhimpur, the petitioner has not yet been taken into custody. Then he shall not be taken into custody and shall be deported to the territory. However, as the petitioner has been declared as a foreigner under the Foreigner Agreement and also found that was illegally entered in the territory of Assam, okay, specified reference to the judge. He shall appear before the Supreme Court order of the Court of Honor 29/01/2024 along with the certificate and all in such appearance. Place this matter for motion immediately on receipt of the 11 reports from the concept partners.
Yes, sir.
May please, Lord. Case 52, my lord, is the order, my lord. Earlier wrong file was tagged.
This time it is right.
Second.
Yes.
Lord, impugn order judgment case 52.
Where is the link document? Link document.
Link, my lord. Page 27, my lord. Prior to that, my lord, page 25, grandmother and father, my lord. Then in 97, father. 65, grandmother, my lord, page 21.
What is the name of your father?
My lord. Purno Chandra De, my lord. Purno Chandra De. And grandmother Renubala, grandfather Gyanendra.
Purnode is your father.
Lordship.
Renewable day is your
Renubala, grandmother, my lord. Sixty-five document, my lord, grandmother. And 71, my lord. And 89, father along with grandmother. Father, my lord, examined as DW2. Page 46. The tribunal, my lord, did not discuss, my lord, DWs, my lord. বাপেক তো নিজেই লিঙ্ক টু বাপেক নিজেই ওই এলআইসি ডকুমেন্টত আছে এলআইসি ডকুমেন্টত আছে আর বেলেগ নাই and one LIC document is there, my lord. Father and
petitioner.
Your Binoy Day.
Your Lordship.
টপিকটো কি হৈ আছে টপিকৰ ষ্টেটমেণ্ট ডিছকাছ কৰাই নাই সুধিছিল টিম মাৰিছিলে তাৰপিছত তাত দিয়া নাই কপি নিদিয়ে 95 নেকি 97 97
Heard Mr. R. Ali for the petition. And Mr. J. Pang, standing counsel from Department of Sound. Response number 2, 6 and 7. Mr. H. Cooley, standing counsel, Election Commission of India for response number 3. And Mr. P. Sharma, additional public prosecutor. Sorry, additional senior government Assam for response number 5. In a reference being made that is Superintendent of Police order Barpeta. The learned member for the tribunal. Corpora 11. At Sorbo. After hearing the petitioner and considering the evidence adduced by him by the impugned judgment dated 27/05/2020, opine the petitioner to be a foreigner under the Foreign Act 1946 of post 25/03/1971. Spring. This satisfied the said opinion, impugned opinion that is judgment dated 27/05/2023. The petitioner filed this petition on 20/12/2023. After more than 2 years, 7 months. Issue notice returnable by 8 weeks. At such a notice no comment is 8 weeks. The respondent numbers are. All the petition will submit with extra copies from Mr. J. Pine, Mr. H. Kuli, Mr. J. Pine, and Mr. H. Kuli, and Mr. P. Sharma. By tomorrow, obtain necessary acknowledgement. Petitioner shall serve with extra copy of this. RKTF Deputy FGI. For the response number 1. Obtaining petitioner shall take step to petition the number 4 by raise the possibility providing its correct. All for the records of RF case number 1862 of 2017 within bracket. Reference number 4876 P of bracket disposed of on 27/05/2020 from the office of the United States of Burden 7 and 11. At Sorbo Police Department. Even the meanwhile, the petitioner has not been taken into custody. Personally, impugned judgment is 27/05/2020. He shall not be taken into custody. Shall not be reported from central media. Person to the said judgment dated 7th. Hello. Petitioner shall appear before the Superintendent of Police Border Paksa on or before 29/01/2020. This matter for report that issue notice returnable by 8 weeks. Maintainability of this petition. Continued delay in filing the same on or after 2 years. 7 months shall be considered the time of its admission stage. Is this matter for admin? Along with the returnable date. Along with the records of the tenant. But when the cost of the content is have. Right. Number 12.
This is a contested matter, you know.
Administrator. It's fully, no, Mr. MS Ivarma and the council from report, let's some for the response number 2, 3, 2 and 3. P. Sharma, legislation response number 4. And Mr. H. Kuli, the council election committee. By the impugn opinion dated 12/01/2023. The learned member Fairness Tribunal First Nogam in FP case number 208 of 2009. Within bracket SP order reference number 554 of 2008. Declared the petitioner to be a foreigner under the Foreigners Act 1946 of 25/03/1971 stream, who had illegally entered into the territory of India from the specified territory of Bangladesh without any valid document. Dissatisfied, the said opinion dated 12/01/23, petitioner filed a said petition on 21/12/2023. So notice returnable by 8 weeks. All for the record of law. the interim petitioner shall appear before the Superintendent of Police Board at Nagaon on or before 29/01/2024. Followed by.
Obliged.
May I please your lordship? Before considering other aspects, may I take your lordship to the interim judgment, page 67, paragraph 14. As per inquiry report, the proceeding was declared citizen. Thereafter, the reference was made my lord. Otherwise, my name is appearing with my father, my lord, in the year 1989, my lord.
You want to say that since the father of the proceedee's name was in the voter list of 1970,
Yes, my lord.
what is the link document?
Link document, may I take your lordship to the voter list of 1989, my lord? Page 19, vernacular, my lord. The petitioner was earlier married with Omar Ali, my lord. And Moziran, this is the petitioner. Kindly see the house number, my lord, 77. And next, my lord, kindly come to page 21. House number 71, Muslimuddin, this is my father. That's because due to marriage, my name has been appearing in the other house number with my
What is the
husband.
link document between Maziran and Muslimuddin?
Regarding link, I have examined my brother, my lord, his statement deposition, your lord, you will find at page 52, my lord. Cross portion, your lordship will find at page 57.
Age. Abdul Hai is his name.
Abdul
What is the name of your brother?
Abdul Karim. Cross portion, your lordship will find at page 57.
Take it. Which is your link document?
My lord,
Link document.
link document I have submitted Gabura certificate, but page 33 and 35, my lord.
Hmm.
But the Gav Pradhan of my birthplace, he was in charge Gaugura, so he could not state the details, my lord. I am an illiterate person, so there is no any school document also. And my name has been inserted in the voter list after marriage only. I obtained right of friendship.
Where is the deposition of the Gambura?
Page 59, my lord.
Abdul Hai. Abdul Hai,
Yes, my lord.
kindly read the cross.
I have been serving as in charge Gaon Pradhan of village Kasumara and Kasumara NC since 2017. I have not done my survey in these two villages, but I have done my work as per the advice of my paralyzed father, who was earlier Gaubura of these villages. I know the opposite party Maziran Nasa as wife of Habiluddin, so I have issued a certificate to Maziran Nasa as she is wife of Habiluddin. I have identified the certificate and the signature on it, and also carry the counterfolio copy of the said certificate. I do not know about the father of the opposite party and from where they were originally belongs to. I have issued that certificate depending upon the voter list of 2022. It is not a
So- So, first of all, this Gambura knows the husband of the petition,
yes, ma'am. Not my father.
not the father of the petition. And secondly, he issued the certificate on the basis of the voter list of 2022.
22.
Right.
Yes,
There is nothing on record to show.
my lord.
Or Mr. S. Ali, Lord Counsel appearing for the petitioner. And MS A. Verma, standing counsel from Department asking for the response number 2 and 3. Also heard Mr. P. Sharma, additional Chiragura Katsan for the response number 4 and Mr. H. Kuli, standing counsel election commission of India for the response number 5. On being referred by the Superintendent of Police Border Kamrup Rural Amingam under the Foreigners Act 19, no, the Circle for Amingam. The learned member of Foreigners Tribunal number 2, Kamrup Rural at Poco in BFT case number 1677 of the 2016. After hearing the petition and considering the evidence that used by her, another opposite party, by the impugn opinion, dated 30/01/2023, who appointed petitioner to be a foreigner, the Foreigners Act 1946. Of post 25/03/1971 stream. Is satisfied with the said impugn opinion dated 30/01/2023. The petitioner filed a said petition on 05/01/2024. Before we proceed further, we like to peruse the relevant records of BFT case number 1677 of 2016, wherein the learned member of Foreigners Tribunal number 2, Kamrup Rural at Poco, by the impugn opinion that at 30/01/2023 declared her to be a foreigner. Call for the record of the consent. Unless this matter for motion will be on receipt of the 11 deposit. If in the meanwhile, the petitioner has not been taken to custody, has not yet been taken into custody pursuant to the impugn opinion dated 30/01/2023 past incident TFT case number 1677/2016 by the London Member for District Number 2, shall not be taken into custody and shall be not be deported from the territory of India. Also, however, considering the fact that petitioner has been declared to be a foreigner under the Foreign Affairs Act 1946, this shall appear before the Superintendent of Police Border, Kamrup Rural, Taminga, on or before 29/01. Rest list according for motion. The 11 record.
Obliged, my lord.
May I please, your lordship? My lord, it is a contested case, my lord. So another one case is pending before this honorable court in the name of his father also, my lord.
Is it? What is the state?
That notice was issued and directed to appear before the SP border
What is
Morigaon.
the number?
That is number, my lord, WBC number 7558 of 2023. And the notice was issued on 22/12/2023.
By the same tribunal?
Same tribunal. I have stated at page 15, paragraph 24, regarding that writ petition, my lord.
Or Mr. K. U. Ahmed, counsel appearing for the petition. And Mr. H. Kohli, attending counsel election commission of India for the action number 2. Also heard Mr. G. Sharma, attending counsel from Department of for the action number 3 and 5. As well as Mr. P. Sharma, additional interior from the Assam for the action number 6. In police preference case number. Just study. In a reference being made by Superintendent of Police Border, Morigaon, Planet Member Fairness Tribunal number 1, Morigaon, in case number F.T.119 of 2012, for hearing the petitioner and other parties and considering the evidence adduced by him by the impugn order to the 26/04/2023 declared the petitioner to be a foreigner under the Foreigners Act 1946 of 25/03/1971 stream. Agreed by this is opinion. dated 26/04/2023. The petitioner filed this petition on 05/01/2024. Same. So, it's- In the meanwhile, petitioner has not been taken into custody pursuant to the impugned opinion dated 26/04/2023. Passed by the honorable member for an established number one. Shall not be taken. Shall not. Petitioner selected. Same as the previous one. 29th of that. Reported to right, all for the records of case number FP 119 of 2012 from the office of Furnace Tribunal number 1, Oregon Sub. That was disposed of on 26/02/2023. Last, place this matter for admit. On which the relevant deposit consent along with WPC number 7588/2023, where each petitioner is the father of the present petitioner, who too was declared as a foreigner under the Foreign Second 46 by the same tribe at Morigo.
My lord, petitioner will appear.
On or before 2019.
Obliged.
Superintendent of Police Border, Morigaon. Yes, Mr. Sharma.
This is an ex parte order, lordship, opinion page 12.
Whether after the order of 14th of November 2023, have you approached the tribunal again?
No, lordship, because lordship, meanwhile 30 days
time for filing review lawsuit that was expired.
Okay. Okay. Okay.
A chance may be given.
We cannot do anything. Third, Mr. T. Sarkar, A.T. Sarkar, counsel appearing for the petitioner. And Mr. H. Kohli, standing counsel, Election Commission of India, for the rest number 2. Also heard Mr. G. Sharma, standing counsel, Home Department, Assam, for the rest number 3, 6. And Mr. P. Sharma, petitioner, Sidhavan, Assam, for the rest number 5. It is contended by the petition on behalf of the petition that the learned member of Furnace Tribunal Third, Dorong Mongoldoi, in FT within bracket 3, case number 6280/2022, by an ex parte final order dated 14/11/2023, declared him to be a foreigner of post 25/03/1971 under the Foreigners Act 1946. From the perusal of the impure final order dated 14/11/2023, copy of the impure final annexed to this petition we have noticed that the petitioner filed his written statement on 18/7/2023. Thereafter, on 11/08/2023, he took time to file his evidence. Thereafter, on 30/08/2023, 21/09/2023, and 16/10/2023, petitioner remained absent in the matter without any steps. On 16/10/2023, when the matter was fixed, even on 16/10/2023, don't write even. On 16/10/2023, the matter was fixed on 30/10/2023 for necessary order. And even on 30/10/2023, the petitioner remained absent without any steps. And thereafter, 14/11/2023 was the date fixed for final order. And accordingly, the interim final order that 14/11/2023 was passed. Before we proceed further, I'd like to peruse the records of FT in bracket 3, case number 6280/2022, wherein the learned member of Furnace Tribunal Third, Dorong Mongoldoi, was the impugn final order dated 14/11/2023. Call for the records. Please this matter immediately, or you can get it, Mr. Sharma. You'll able to get it? Okay.
Very, very low.
এইটো ন দৰং দৰং ন
Sixth of February,
লৰ্ডশ্বিপ
released on sixth of February. And on the same date. Mr. G. Sharma, standing counsel from department. Appearing for the respondent numbers 3 and shall produce the relevant records. In original. Pertaining to FT3 case number 6280 2020. But in the Indian final order, the 14/11/2023 noted was passed. Copy of this order will be furnished to Mr. G. Sharma during the course of the day for his onward community. List.
Lordship, kindly allow me to appear. Lordship, order may be stayed.
We'll see on sixth.
Lordship, police is searching, Lordship. We have explained everything in there are 5.
Can't help you. It is not a case that you are not aware the matter was pending before you.
Due to communication gap, Lordship, with the advocates, Lordship, they did not inform.
We'll see
Lordship,
on
kindly
sixth.
consider, Lordship.
We'll see on sixth.
The-
The petitioner is very
We have also an
expert. What is the date of obtaining certified copy in your writ petition?
That is not here, Lordship, date of.
Why it is not here? It has to be there. It has to be there in the last portion. It has been blocked. It is not available there. Don't think that we don't notice all this. Yes, next.
May I please the lordship
Lordship, petitioner was declared foreigner lordship by ex parte order lordship. Page lordship 25 lordship, ex parte order. Actually, she did not receive notice lordship. Page 25 is the lordship, 25 lordship, impin order lordship. Actually, she did not receive notice lordship. That's why he could not appear lordship.
Yes, Mr. Sharma, here also get this case. Please come to page number 25,
Yes, Lord. Yes.
second paragraph.
Notice was issued to the opposite party. However, it seems that due to lack of any proof of citizenship and fearing adverse inference by the concerned authorities, the proceedee oblique opposite party had left the village in order to intentionally avoid the service of notice on her. Finding no way out, the process server of border police pasted a copy of the notice on conspicuous place as per the provisions of law in presence of village headmen and local people, and reported to this tribunal completing the service of notice.
Right,
Lordship.
now please come to page number 13. Read para 14. Page 13, paragraph 14.
That the petitioner begs to state that Gaubura, Gao Pradhan of village headman of the village, Pakalji, wherein her
Pokalani.
Pokalaji, wherein her in-laws house located. The Gaubura issued the certificate dated
There's a
2/11/23.
certificate. The Gaungura resides there itself,
Yes, Lord.
in her in-laws house.
Yes,
And
Lord.
the same Gaungura.
Yes,
May not be different Gaungura, I don't know, but the village headman was there. But
yes.
the notice was affixed in her house at Pokalik. Now come back to page number 25 again. You see the same address.
Same address, Lordship.
And the finding of the tribunal was she left that place.
Yes, yes.
She left that village,
Yes, Lordship.
right?
Yes.
So you have the records, let us see.
Yes, Lord.
When
Lordship. As your Lordship. 1 week, 2 weeks time, Lordship.
2 weeks time,
Lordship.
fifth,
Yes. 5th of February.
Till then,
release
Lordship.
this matter on 15, 05/02/2024. Let's say that Mr. G. Sharma, Standing Council, Home Department. 12 place. The records in original pertaining to FT case number 50 of Paksa of 2019. Wherein the learned member Foreigners Tribunal Baksa Tamulpur by order dated 14/01/2000 by an expertly order dated 14/01/2020 declared the petitioner to be a foreigner under the Foreigners Act 1946. Illegally entered into territory of India within Kolkata Sound from the specified territory on or after 25/03/1970. Copy of this order be funded in Mr. Standing Council Home Department or his necessary respondent.
Till then, Lordship, interim protection may
Order
be
is let the record.
obliged, ma'am.
Yes, Mr. Lockhart. We are fixing this matter on 19th.
19.
Please this matter on 19th of the.
May I please, your lordship? This is the custodial debt matter, my lord.
Oh, that matter.
Yes,
That
my lord.
matter.
Do you have the report?
You have file affidavit, man. There's a director to file affidavit on.
The matter where
It was from Dhemaji, my lord.
got it. Jump from the bus.
Yes, my lord. And as per your lordship's order, on 24/11/2023, we have filed affidavit, my. Details affidavit, we have filed.
When did you file?
20. 13/12/23, my. 13/12. 13/12. It is okay. It is okay. Passport also it was. Yes. And we are stated, my lord, there are 2, 3, and 4, my lord. Next, sir, one minute inquiry report.
1, 2, and 3. 2 complete. Open. Calculation to the 32. Itu itu kepemimpinan.
Without cumulative.
কিন্তু order করা না পড়ে গেছে আমার লাগে নেক্সট কিন্তু দরকার না কিন্তু এটা মনে হয় একটু একটু অবশ্যই অলরেডি দেওয়া আছে 1 লাখ টাকা এই লইছে এটা এডমিট করছে one no one same to you
medical report was Human Rights Commission. Yeah. To payment for carefully. Department eligible time management to the The amount was paid to whom?
paid to my
To whom?
no but
To the petitioner, my lord.
petitioner
Petitioner.
so now is 1 lakh was wait huh? As per the order of Human Rights Commission, he approached before earlier Human Rights Commission.
No.
Yes, yes, yes.
SP for
আবার বলছে
আমি human right plan
অর্ডার দেওয়ার মানে
Yes, we'll come back and do
my lord.
and see.
Page 64 all clear is that my lord. Page 64 plain given. Page 64 finding submitted Charan Dole so and so departmental process against charge appears so 2 annual increments of stop.
That we have seen.
Yes. Let's go.
Come back at me.
Oh. Nanti ko din.
Mr. Salim, just tell us, what do you mean by custodial debt?
Custodial death, my lord, for any action or omission. Both includes. Here, my lord, in this case, for the negligence of the duty of the government officials, police personnel, the son of the petitioner died, my lord. So, my writ petition was with twofold prayer, my lord. One for inquiry for the punishment of the erring officers, and the second for compensation, my lord. Regarding first part, I do not think the said prayer has any force now, as because the said part is over. But regarding compensation, my lord, I have already been paid 1 lakh, my lord. My only submission is that this is not sufficient, my lord. And for the authority, my lord, I would like to rely on judgment of coordinate bench of this honorable court, my lord. 2022 3 ZLT 187. 2022 3 ZLT 187, my lord. This is a long judgment. I do not want to take your lordship through the entire judgment, my lord. In this case, what happened, my lord? The quantum was determined after discussing the landmark judgments of the Honorable Supreme Court and thereafter various high courts. And finally, after discussing various judgments passed by this Honorable Court, my lord. So, may I read the relevant portion, my lord? 2022 3 ZLT
Thing is coming.
page 187, my lord. Conto Orissa, Union of India, my lord. I would like to refer some particular paragraphs from paragraph 99, my lord.
Just a minute. Read para 4.
My lord.
Read para 4.
According to the petitioners, from the nature of the injuries as indicated in the postmortem reports, it was very clear that the said 2 persons received bullet injuries, which are antemortem in nature, and death was caused due to shock and hemorrhage. It has been alleged that the
So
postmortem
background of the case. that
something different,
the
my lord.
victim
Something
sustained
different, my
bullet
lord.
injury. Now here, what is the postmortem report?
Postmortem report, injury on various parts, head, back.
See, basically, the report is very clear.
My lord.
All the under trial prisoners were carried to Hemaji, right?
Well,
The bus have 25 under 10 male under 10 prisoners and one female UTP. And during that period, the victim jumped from the bus
Yes, my lord.
because the door was,
Some broken lock
the
broken.
lock system was not good.
Yes,
So
my
he
lord.
jumped from the bus
My lord.
and sustained head injuries and other injuries on his parts of the body,
My lord.
and he expired. Now, in that circumstances, whether it will amount to a custodial debt,
Now, my submission, my lord, is that here the police official did not met upon some or
so
any.
in that circumstances, because the evidence while punishing the officers concerned, or hearing officials, hearing police officials, it is very clearly it was there. The report of the concerned officer submitted before the deputy commissioner of police also very clear that he jumped from the bus.
My lord, but your
And in
lordship,
that report, there is another particular point raised, I will say that from the evidence, that the handyman of the bus somehow survived from the similar accident, because as the victim jumped from the bus, opening the door, he could manage to hang on that particular door, in the hinges of that door. It is there in the report. Now, in these circumstances, whether it will amount to a custodial debt or not,
my lord, my submission is that your lordship will kindly consider one thing, that for action and inaction, both is included for
for
custodial debt.
election, yes, the police officers' actions have been taken against them.
Yes, my lord.
Right.
My lord.
Now, there were other UTPs in the bus,
Yes, my lord.
not only this particular victim, there are other UTPs. So in these circumstances, whether do you say that it is in the custodial debt? Because considering those aspects and the report submitted by the authorities, the National Human Rights Commission has already granted compensation of 1 lakh to the next of kin of the deceased.
My lord.
Tell us whether this will amount to custodial debt.
My
That is why I wanted
understanding,
to know what is custodial debt. You said action, inaction, both.
both, my lord.
Is that much, that is sufficient? Because in that case, certain amount of compensation has already been paid to the
Yes, my lord, I admit.
next of kin of the deceased.
My-
Now your claim is that that compensation amount is not sufficient.
Sufficient, my
Keeping in mind the background of the case, whether there is any possibility of enhancement of that amount.
Regarding that, my lord, I would like to rely on judgment of this honorable court, my lord. 2018 Criminal Law Journal 4207, my lord.
Do you have the party's name with you?
Yes, my lord.
2000?
2018 Criminal Law Journal 4207, my lord.
Downward tape to it.
I have extra copies, my lord, if required, my lord.
You have,
My lord.
please. If you have one copy, that will do, we'll read together.
Paragraph 2 may kindly be seen. And thereafter, my lord, paragraph 11, my lord. He sustained injuries during judicial custody. And regarding compensation, my lord, I would like to rely paragraph 11, my lord. Last sentence, my lord,
paragraph 11. The payment shall, however, not foreclose the opportunity of the petitioner to claim further amount by establishing the actual loss suffered by the family through an appropriate proceeding. So this categorical statement means that the actual loss should be compensated, my lord. I have lost my son, my lord. It cannot be measured in terms of money, my lord.
That is absolutely correct. The thing is this, the reason we are asking you what is custodial debt in these circumstances. If you are saying so, let us assume, let us a scenario that the bus met with an accident.
My lord.
Will it be amount to custodial debt?
No.
The bus fell in a ditch. Bus fell in the ditch.
There is no negligence, my lord.
No. Bus fell in the ditch. Because one of the UTP in the bus tried to commit some kind of stunts there, either on to jump or to something in that process. Right? That is the reason. See, every case differs. There is a fact, the victim suddenly jumped from his chair through the door, fell down under. Injuries sustained by him is not of any atrocities on his person, because in that particular bus there were 20, altogether 26 UTPs and 11 police personnel. The person jumped, so 25 male and female UTPs were there. So that backdrop, whether it will amount to a custodial debt or not.
At present, my submission is that although in my petition I stated that he was tortured, but now my submission is not that. From the report, it is clear that for the negligence of the police officers, the accident occurred. And for that negligence, I am entitled for compensation. That is my submission, ma'am. And the judgment I have submitted before the Honorable Court, Konto Warisa, there, after discussing the entire judgments of the Honorable Supreme Court as well as other high courts, as well as this court, it is held at paragraph 113, my lord. Accordingly, the
thing is
respondent.
that, the background of that case is that there were bullet injuries on the person of the deceased.
Yes, my lord.
And here is a case where the man had 24 injuries while he was in jail.
My submission is not that whatever the amount was paid in that case, I
We are
am
not on
entitled
the
for that.
amount. We are on the background of the case. You have submitted, Mr. Salim, that since this incident took place because of the negligence on the part
Yes,
of the
ma'am.
police personnel
Yes.
accompanying the UTPs to the Dhemaji jail, you are entitled for compensation, further compensation.
Now the amount 1 lakh is not sufficient, my lord. That is my submission before this honorable court. As because this, as per this judgment, after discussing the entire judgments, Supreme Court granted in various
True.
cases.
But if you go to the facts of the cases, you will see the different natures of the facts that are explained there.
All cases are different, my lord.
Yes, Mr. Sharma,
Lordships. Lordships, not a custodial death, my lord. Your lordship see that police,
where the custody means what?
if-
Custody means what?
Custody means if he is in jail custody in other country, then police torture him, if the bullet injured, that is sufficient defense, man.
Whether at the time of the incident, the victim was in the custody of police personnel or not.
We are police
He
custody.
was in the
Police
police
custody,
custody.
my lord. He is, they are going to Dhemaji to Jonai, my lord. There is no any jail in Jonai.
No, from Junai, they were going to Dhemaji.
Dhemaji. And at the time, my lord,
So,
that person jumped from the bus, my lord. He
Now,
himself,
is not it a fact that the police personnel failed to provide security to the UTPs?
my lord, security, definitely security that was provided, but in the meantime, the running bus was that nobody knows that he will jump, my lord.
So
Police
that's why.
personnel, the police personnel also is there, my lord. For total 26 person was there. He suddenly, my
So
lord,
according to you, the person concerned was in the custody of the police.
That is the police custody. He is coming from Jonai to damage matter. But he jumped,
As because there was no proper protection,
and there is
the
sufficient
victim
protection.
could jump off from the bus.
My lord, he suddenly jumped from the bus. My lord, the police force was there. But in the meantime, he opened the door, he jumped, and that he injured one. And for that reason, my lord, already authority paid 1 lakh rupees to him. And that concerned police
So is
officer,
that is sufficient?
concerned police officer shall also sufficient punishment, their increment also is stopped and their
Is that
punishment.
sufficient?
My lord, that is 1 lakh, it is not a bullet injury in other, your lordship see. Not police torture, my lord. He himself jumped from the bus, my lord.
UTPs normally are kept under handcuff, my lord. Under such circumstances, how he can flee away from the handcuff?
From
Handcuff, days are over.
over. That is already over. If anybody shift from one jail to another jail, no and
Our High Court, very recently, Brother Justice Borua has passed an order, right, for handcuffing. Gave a cost of 5 lakh. Have you heard that judgment? Have you
Yes,
read the
ma'am.
judgment? Much prior to that, anywhere in India, our High Court passed an order.
But from
Granting
the
2 lakhs. Have you not read the judgment of Niloy Dutta while he was in custody? He was handcuffed. Because of handcuffing Niloy Dutta as he was then, the court granted 2 lakhs of compensation to him. Have you not read that judgment? You should read that judgment. Everything was discussed in that judgment.
I have read the recent one, not the earlier one, my lord.
That was the judgments. You should read what happened, why the reason for giving compensation for handcuffing Niloy Dutta.
Yes.
And you know who is Niloy Dutta. Should read.
But in this case, it is not my submission that they should be handcuffed. But the report says that they were handcuffed.
No.
If your lordship goes through the record, proper handcuffing was there. Handcuff logo আছে.
Inquiry report.
Please take your seat. শর্মা আকৌ সেই বেমাৰটো আৰম্ভ হৈছে যোৱাকালি যিটো বন্ধ কৰিছে কাটি কাটি যায় Yes, tell us what will the amount you are looking forward will be reasonable enough.
It is up to the honorable court, my lord.
Tell us why it is less and what will be the sufficient amount.
Can it be total 3 lakhs? One is already paid. Can I pray for remaining 2 lakhs?
1 for the petitioner, half of it for the petitioner,
My lord.
and half of it for the petitioner's counsel. Okay, we'll see. We'll pass the order. sister will not be available. So maybe after she returns or in between, we'll have it. We'll give the date later on.
I am obliged, my lord.
Mr. S. Alim, learned counsel appearing for the petitioner. And Mr. P. Sharma, additional senior computer sound. Mr. List of tweets. Audit line today. For necessary order.
Highly obliged, my lord.
Obliged.
Please, your lordship, I beg pardon, my lord. These is may took time, my lord. Your lordship, I mean, and one short date is
Tell us when.
after immediately after.
Do one thing, let them submit their this thing if they are ready, and you take it note, then you make your submission on the next day. Will that be enough? But
Not in this case, madam. Not in this case.
oh,
This is
not in
not.
this case.
আপনার কোন পাইছেন?
Oh,
20,
so after,
item
I
20.
can understand, item 20,
Yes,
you want some other day,
yes, ma'am.
give us a date, give us a date.
Immediately after 22, 23. As your lordship on
22nd?
right.
Under prayer.
My lord, this is a writ petition filed by the state, my lord, against the opinion dated, my lord, Page 10, my lord. It is opinion dated 13/10/2016. Page 10 is the opinion, my lord. My lord, the ground for filing this writ petition is mainly because, as I always argue, my lord, this court being certiorari jurisdiction may not have the power to go to the, my lord, internal facts, the facts found by the, my lord, the tribunal. But there is also an exception for that, my lord. Just before going to the tribunal, I'll just point out one thing from this, my lord, this.
If the finding is perverse, definitely within
Yes,
certiorari it can
yes.
be gone through, but
My
thing
lord,
is that has to be.
certiorari, my lord, because what I'm relying. First of all, I want to, my lord, clear that point, my lord, para 112 of the, my lord, that Muslim Mandal. Just one line I'm reading, my lord, because it may come against me also. In fact, the certiorari jurisdiction of the writ court being supervisory and not appellate jurisdiction, the court cannot review the findings of the fact raised by the inferior court or the tribunal. There is, however, an exception to the said general principle in as much as that writ of certiorari can be issued and the decision of the tribunal on findings of fact can be interfered with when, my lord, if in recording such a finding, the tribunal has acted on evidence which is legally inadmissible or refused to admit admissible evidence. So my submission is that in the present case, my lord, the learned tribunal has acted upon some, my lord, legally inadmissible evidence.
Legally inadmissible and legally, there are two conditions.
Yes, legally inadmissible or has refused to admit the, my lord, admissible evidence. So in that case, this honorable court has the power to interfere in the facts finding of the murder tribunal. So here is the case, my lord. The tribunal has considered some documents and, my lord, the evidence, oral evidence of 2, 3, and 4. The lordship will find the, my lord, the from para 7 onwards, your lordship made it and see. Page 2 of the internal page 2 of the opinion, my lord, para 2. First documents is, my lord, the petitioner exhibited, the, my lord, the proceeding exhibited before the tribunal was the NRC extract, that is exhibit 1. para 7, my lord. The proceeding adduces evidence of true affidavit and OPW 1 and exhibited 12 numbers of documents in support of the claim to be citizen of India. In his deposition, proceeding deposed that he is a bona fide citizen of India by birth and permanent resident of village number 3 Bartala under Mukalma police station, Nalbari district. He born and brought up at village number 3 Bartala. His grandfather's name Monuruddin, son of Biru, and his grandfather's name appeared in NRC. This is the voters 1951 Exhibit 1. Exhibit 1 is photocopy of NRC issued by the president. My lord, even this Kamrup district Jamiat Ulema Hind, which is proof in original. This is the first documents, my lord. I'll come to the, my lord. May I, my lord, argue on this point, my lord? First of all, my lord, it is settled position that NRC documents cannot be taken as evidence. And secondly, my lord, the Jamiat Ulema Hind has no authority to issue NRC documents of such kind. And on the basis of such document, if the person is declared Indian, my lord, it cannot be accepted as a my lord, legal, because this document itself is not admissible. So for the first point, my lord, my lord, para-wise, I want to rely on some judgment of my lord. Regarding this, my lord, I just want
What
to
is the finding of with regard to Exhibit 1?
Exhibit 1, my lord, they have accepted it.
No. Whatever the tribunal in
The
his
tribunal has,
finding opinion has discussed that.
no, there is no
Exhibit
details
1.
discussion.
No reason.
Let me go through the entire opinion, my lord.
Right.
Yes. Exhibit 1 is the photocopy based on that is issued by Jamiat Ulema Hind, which is proved in original. His grandfather and father's name appeared in the electoral roll of the year 1971 by so-and-so, village Barmara, under 61 Hajo, LAC. His grandfather and father's name appeared in the electoral roll of 1977. 1977. Then so-and-so, house number so-and-so, village Barmara, under so-and-so constituency. His grandfather and father's name appeared in the electoral roll of year 1985 by so-and-so and so-and-so, village Kapalbari, number 2 Kaplabari, number 3 Bortola, Exhibit 2. My lord, Exhibit 2 is the voter, my lord, 1985 voter list. Exhibit 1 is the NRC, my lord. Exhibit 2 is the 1985 voter list. It's the photocopy of the said voter list, which is proved in original. Proceeding further deposed that his parents' name enlisted in the voter list of in the year 1990 by so-and-so, village Kapal so-and-so. His parents' name enlisted in the voter list of 1997, so-and-so, in village so-and-so, under same constituency, but there is, and this Exhibit 3, madam, the 1997 is Exhibit 3. Is the said voter, Exhibit 3 is the said voter list, which is proved in original. His and his father's name enlisted in the voter list of electoral rule of 2006, Exhibit 4 is the said voter list, which is proved in original. His and his parents' name enlisted in the voter list of 2010 at so-and-so, that is in the same Bortola village, Borkhetri LSC. His and his father's name enlisted in the voter list of 2014, that is in the same village, that is Exhibit 5, which is proved in original. He and his father's name also appeared in the voter list in village number so-and-so, under so-and-so Borkhetri LSC. The Election Commission of India issued electoral photo identity card, that is Exhibit 4. Exhibit 6, electoral photo identity card is Exhibit 6, photocopy of identity card, which is proved in original. Village Hetman, number 3 and 4 Borotola village, issued a certificate in respect of his father, residing at Exhibit 8, 7 and 8A as certified certificates. He and his PAN card, he has a PAN card issued by Income Tax Department. This PAN card is there. Exhibit 8 is the photocopy of the PAN card, which is proved in original. His grandfather purchased a plot of land in 1950. Accordingly, a deed was executed between the serial number so and so seller, namely Kundu Sheikh, and his grandfather, namely Manuruddin. Exhibit 9 is the photocopy of the said sale deed, which is proved in original. His grandfather possessed a plot of land, and accordingly he paid land revenue by receipt number so and so, so and so. The exhibits are land revenue paying receipt exhibit 10A, 10B, my lord, receipt exhibit. Then a grandfather title deed was executed in between his grandfather and Raizuddin on 8 March 1355 as exhibit 11 is photocopy of the said deed and proved in he denotes an amount of rupees, he donates an amount of rupees, he donates an amount of rupees 50 paisa towards National Defense Funds on 25/10/1965. Exhibit 12 is the photocopy of said receipt, which is proved in original. Proceeding further reports that border police never visited. These are the findings against them. Then your lordship may kindly see the findings. My lord, page 6, my lord, internal page 6, last para 10, my lord. This is the finding. I have perused the reference, report of the inquiry officer, and a statement of the proceeding, and other witnesses recorded by inquiry officer. I have also perused the written statement, evidence, witnesses, and document exhibited by the proceeding in support of the claim and evidence of inquiry officer. In the reference case, name of the proceeding has been recorded as Raham Ali, son of Babar Ali, OPW 1. Proceeding deposed that his father's name is Badaruddin Badar Ali and grandfather name is Manuruddin. Report 36/2016 confirmed that Monu alias Monai alias Manuruddin was one and same person. Name of the Manuruddin recorded in the NRC issued by, this is my lord, findings on NRC, that's relied on. Name of the record in the NRC issued by Kamrup District Zometolime Hind on 21/9/69. Grandfather's name of the procedure also appeared in the land said that dated so and so, mark so and so, dated 22/5/1950. Exhibit 10. Land revenue paying receipt dated so and so, so and so. Exhibit so and so reveals that the name of the grandfather of the proceeding. Receipt dated 25/10/65 also reveals that the grandfather name and the proceeding. Exhibit 12. Name of the Badaruddin record in the voter list of 1970, 1977, 1985, 1990. Exhibit 4, 5, 6, and 7A reveal the name of the proceeding. Son Badaruddin, who is one and same person as per report and so and so. Evidence of OPW 3, 4 are corroborated with regard to the father and grandfather's name of the proceeding. The state has not rebutted the evidence of the proceeding as well as other witness in respect of the father and grandfather names of the proceeding. Accordingly, I am of the view that evidence from documents exhibited and produced by the proceeding are trustworthy. So on the basis, my lord, the proceeding has been declared for Indian, my lord, not foreigner. Now, the my lord, tribunal has relied on, my lord, the NRC documents first. So NRC documents, my lord, it is the settled position. NRC documents cannot be used as a piece of evidence. And my lord, secondly, my lord, this NRC, even though we accept that NRC documents can be used for the purpose of evidence, it is not in fact. Then also, my lord, this is a certificate issued by some private organization, and NRC documents issued, who has authorized that private organization to issue that certificate? And the tribunal has relied on that, and relying on that, my lord, he declared the person. Here, before going to the other aspects, my lord, what is the case here? My lord, the petitioner has, the father of the petitioner, my lord, who is claiming to be Badaruddin. First of all, it has to be established that Badaruddin is a citizen of India. My lord, para 26 of the Sobananda Sonal said, has specifically said what evidence they need to be bring to the tribunal. They have to bring the evidence of the date and date of birth and place of the petitioner or proceeding. Secondly, the citizenship of the father and mother. That has to be established. So here in this case, the first question, whether Badaruddin is a citizen of India or not, that fact has not been established. That is, that fact has not been established. So first of all, that has to be established, my lord. They have relied on, secondly, my lord, one thing your lordship will find, they have, though they relied on the voter list of 1966 or 1970, yes, 1971, 77, these two voter lists were not exhibited before the tribunal. Some
History.
Yes, 71, 77. 85 they have exhibited. It's exhibit 3, my lord. Exhibit 2 is the 1985 voter list. Exhibit 1 is the NRC. Exhibit 2 is the 1985 voter list. These are the two voter lists. These are the two documents. And in fact, they have, so existence of the father of the petitioner prior to 1971 is not there. NRC paper. 71 NRC paper.
DW3 is the person who appeared and said before the tribunal that those voter lists are not available.
Yes, ma'am. Those voter lists are not available. They have those submitted, the petitioner submitted the photocopy of some voter list of 1971, 77, but those are not exhibited. So those are not proved. And now, the tribunal has relied on those voter lists. Those are not admissible in law. So documents which are not admissible, that cannot be used for the purpose, as evidence. And Gaonbura came, Gaonbura has deposed, issued a certificate. That certificate was not issued on the basis of contemporaneous record. He did not brought any record to establish this fact.
Yes, Mr. Wang,
Well,
let us see that exhibit one,
yes,
that particular 69 NRC, not a valid piece of document.
Yes.
For a reliable, it's not a piece of reliable evidence.
yes,
And the 71 voter list not proved.
not exhibited, my lord.
Then what?
My lord, may I submit it serially, my lord. First of all, my lord, they relied on the the NRC is not admissible. Then 71, 77,
Not
this
proved by the
not
control
proved by,
officer.
and these were not exhibited in fact. So
Even
photocopies.
if it is not exhibited,
Yes,
also not been
yeah,
proved.
not proved. Then, my lord, the one thing, my lord, even though we accept that NRC document was there, NRC was in the name of grandfather. And grandfather, that NRC, the village name is different. Village name is, my lord, some Gilikmari in 19 Bellingimari or Bellingimari. That is page, my lord, NRC is page 58, my lord, of the record, my lord. Page 58 NRC document is there. That is of some Bellingimari. And the petitioner now residing at Bartala, number 3 Bartala. So that is, first of all, my lord, NRC is not admissible And even though it is accepted, it is of a different village. And if there it was Monuruddin, son of Bidu. Now in 85 voter list, my lord, 85, it is Monuruddin Ahmed. One Monuruddin Ahmed was there, son of Bidu. And 85 page 69, my lord. Monuruddin Ahmed. It is Monuruddin Ahmed, aged about 80 years, and Badaruddin, aged about 35 years. That is the first voter list exhibited or legally admissible. If it is, as it is a certified copy, it can be accepted as a secondary piece of evidence for that purpose. So this is the first documents of existence of this Badaruddin at the age of 35 years.
But even in that exhibit.
Yes.
Exhibit 2, the name of the concerned officer of the election officer and his full name and the date of issue is not there.
Not there.
Anyway, that
Yes.
is a different
Yes,
subject.
that's a different subject. But first existence of the petitioner is, one of the father of the petitioner is 1985. So it is a post 1971 documents. Existence of the father of the petitioner is not proved prior to 1971. And 85 is also 85 to 85 is in a different village. It is in Bartola and Kapalbari. Now, my lord, your lordship may kindly see 2006 voter list, which is the voter list where the petitioner and the projected father is together. Page number. This is exhibited as exhibit number 4, my lord.
Exhibit 4,
Exhibit 4,
2006.
2006 voter list. This is the voter list of where my lord petitioner is claiming relationship with one Badr Ali, who is showing to be father of the petitioner, my lord. Raham Ali. Here, the my lord, it is not Badaruddin Ahmed. Here, the father is Badr Ali. And son of Monu. So the 85 and 65 voter list is different, my lord, first. There is no proof. It is not proof that this Badaruddin of 1985 and this my lord Badr Ali of 2006 is same in one person. And this Badr Ali of 2006 is the son of my lord that Monuruddin, whom they are claiming that as his grandfather, and his existence was there in prior to 1966 on the basis of the my lord that NRC document. So this is not only my lord, there are numbers of my lord law falls. First of all, my lord, the NRC is not admissible. Then, even though it is admissible, my lord, there it is Monur. Then 85, it is Monuruddin Ahmed and Badaruddin Ahmed. Different village. Again in 2006, it is Badr Ali, whose father is Monu. So this is not clear. From this evidence, it is not clear, my lord, that Badr Ali and Badaruddin Ali Ahmed of 1985 is same in one person, and that Badruddin Ahmed of 1985, Badr Ali of 2006 is the son of Manuruddin. Manuruddin of 1951 NRC. He is simply claiming he is son of Badr Ali of 2006, and Badr Ali has to establish, my lord, that he is son of Manuruddin of 1951 NRC, who was there in India in 1951. That fact is not established. If we accept that, my lord, the NRC is a valid document, but we cannot accept it that on that ground also, my lord, it goes. There is no existence of Manuruddin prior to 1985. My lord, if he was in NRC in 1951, his name should be there in 1966, voter list of 1965 or 71. But they produced the first voter list, their first voter list is 1985. At the age of 80 years, projected grandfather, and father 35 years. Up to 85 years, he has no voter list. That Manuruddin Ahmed. So these are the defects, my lord. These were not considered during the time of my lord, by the tribunal. This is first fact, my lord. This has to be established. Secondly, my lord, the legally inadmissible documents he have admitted, the 71, as I have said, my lord. Then he has, my lord, considered the evidence of, my lord, Gaon the Gaon certificate.
No, Gaon certificate.
Was issued in the name of father of the petition.
Prafulla Majumdar.
Yes, ma'am. He has not proved the certificate on the basis of contemporaneous record. He has just appeared and
See,
given some statement.
basically what we found, the voter list 85
Yes.
relates to 2 number Kapalbari and 3 number Bortola.
Yes.
Manuruddin Ahmed, Badruddin Ahmed.
Yes.
Now, next voter list of 97, Exhibit 2, Exhibit 3
Yes.
relates to 1 number Bortola, 2 number Kaplabori.
Yes. They are Badruddin and
One
wife of,
Badr Ali,
and wife.
son of Mona, and one Kulmala Begum, son of Barot,
Kulmal
son of Barot.
Boro.
Then Exhibit 4 is
97.
of village
2006.
2 number Kaplabori
Yes, ma'am.
and 1 number Bortola. Now,
There
this is from just sound. This is from 1 number Bortola.
Yes.
One Badr Ali, everything the village is changing. Badr Ali, Pita Mono, then Raham Ali. Pita Badr.
But village is Ek number border.
2 number Kaplabari and 1 number Bortola. Exhibit 4, voter list of 2006. Then Exhibit 5, voter list of 2014. Boduruddin, Pita Monuruddin, Raham Ali, Pita Boduruddin. That relates to Ek number, 2 number Kaplabari. Then the exhibit 6 is the EPIC card of the petitioner. There his address is, if you see, Raham Ali, son of Boduruddin, village is 2 number Kaplabari. He exhibited.
Yes.
Now the certificate of the
Gambra.
Gaura, Prafulla Majumdar, with regard to Boduruddin, saying that he is a resident of 3/4 number Bortola Gaur Bakinda Lok hoy. 3/4, 3/4 Bortola Gaur Bakinda Lok hoy. The EPIC card relates to number 2.
Number 2
The
Kaplabari.
previous voter list relates to first one is number 3 Bortola, the rest are number 1. The subsequent voter certificate by the same village headman with regard to the petitioner Raham Ali also relates to 3/4. And this particular village headman is for 3 and 4 number lot, not for other village. EPIC relates to number 2.
Yes. All these discrepancies were not considered, my lord. These were not looked into at that time by the tribunal. And the foremost thing is, my lord, the existence of the father of the petitioner prior to 71 is not there at all. This is the basic root, my lord.
Read the written statement. Do you have the written statement?
No, my lord.
Any citation you want to place?
Yes. My lord, first of all, my lord, your lordship. My lord, this is 6090/2016, my lord. Six zero nine zero 2016. Abdul Majid versus Union of India, my lord.
Yes.
Para 11. That is with regard to, my lord, non-admissibility of the, my lord, NRC document.
The earlier
Yes.
judgment, the first judgment.
Yes,
you have
first judgment is, my
some
lord.
report.
Yes, that is, my lord, 1970 Assam LR 206.
1970.
1970, my lord.
ALR.
Assam LR, my Assam LR 206. Bhanbhasa Sikh versus Union of India.
This is
Yes.
Parvati Prasad Goswami.
Yes, my lord. Single bench judgment.
206.
Yes, 206. LR 206. That has been affirmed in this para.
Reiterated, yeah.
Yes, reiterated. No, that is not upheld because this is a division bench. That was single bench order judgment, and that is upheld by litigation. May I read the para 11, my lord? That Exhibit 1 is stated to be true copy of the National Register of Citizenship NRC 1951 issued by the Deputy Superintendent of Police Bodan. Here it was this SP Bodam, Dhuburi on 1985, containing the names of Farad Diwani, Beltol Nessa, Madan Sheikh, and Hanif Sheikh. NRC 1951 was prepared on the basis of the Census Act 1948. As per Section 15 of the Census Act 1948, record of census are not open to inspection and thus not admissible in evidence. Therefore, in Banbasa Sheikh versus Union of India 1970 Assam LR 206, a single bench of this court categorically held that NRC extracts produced to prove domicile in India is not admissible in evidence for any purpose. We are in complete agreement with the views expressed by the learned single judge in so and so. Therefore, Exhibit 1 is no evidence in the eye of law. That is NRC documents. Here also, my lord, the NRC was produced. In the same judgment, my lord, another issue was settled that photocopy cannot be treated as a valid piece of evidence. Para 17. In the same judgment, my lord, Abdul Majid, it is there. Para 17 also referred to, that is in with regard to the my lord, because they have relied on some photocopies in the my lord, in the volume 6. My lord, para 17, it is said Exhibit 6 is the photocopy of the electoral roll of Abhaipur South constituency of 2014, where the name of the voter is Abdul Majid, son of Abdul Matin, aged about 30 years. If Abdul Majid was 30 years of age in 2014, it would mean that he was born sometime in 1984, which is contrary to the date of birth mentioned in the school certificate. That is not necessary. Then, my lord, that apart, this photocopy cannot be treated as a valid piece of evidence because there is no certification at the bottom of the document that it was a certified copy of the original or to be treated as certified copy and thereby secondary piece of evidence. Therefore, the documents would be of no assistance to the petitioner. That is with regard to my lord, because they have relied on 1971 voter list and 77, though it was not exhibited. On the same point, my lord, that whether the photocopies can be accepted as a secondary evidence, that there is another judgment of this honorable court, my lord, WPC 7669 of 2016.
WPC
7669 of 2016, madam.
7669.
Yes, ma'am. 206.
7669.
Yes, 7669 of 2016, madam. It is Borhan Ali. They are in para 21.7, madam. 21.7. If a proceeding relies on the voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned or unauthenticated or uncertified copy of voter list sought to be relied upon as proof of citizenship would not be admissible in evidence. Therefore, we would respectfully disagree with the view taken by the Odisha High Court. Odisha High Court has some taken view. This is clearly said. So here in this case, my lord, the petitioner, the proceeding relied on the 1971, and that is accepted by the tribunal, which is not admissible at all, as per which is legally not admissible. So this, ignoring this, my lord, he has accepted the 1960, 71 and 77 voter list. And pass the opinion, my lord. Are we? Further, my lord, document evidence. Gaur. Ramila. It volume C to 10. My lord, another judgment, my lord, that is how to documentary evidence has to be proved because the Gaur has submitted a voter list, my lord, submitted a certificate, has given a certificate that is not proved. That is, though he has come, but it has not been proved by bringing my lord contemporaneous record. So that aspect was there. That is, my lord, numbers of judgments are there to that effect, my lord. Just I'm relying on as on now, my lord, 3806 of 2016.
Hmm.
3806 of 2016. Romila Khatun versus Union of India, my lord.
PRA.
Yes, my lord. Romila, ROMILA. Romila Khatun. 3806 of 2016, my lord. There it will be para 22, my lord.
3806, no?
Yes, my
Para?
Para 22, my lord. Here it is said that it is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of contents is another. Not only the document would have to be proved, but its contents would have to be proved. That the truthfulness of the contents of the document would also have to be established from the record. A document or the contents of the document cannot be proved on the basis of personal knowledge. So the Gaur deposed there, my lord, but Gaur has not deposed on the basis of contemporaneous record. What he has deposed on the basis of personal knowledge. Here in the next to that, my lord, it is said, when the Gaur had issued the certificate, Gaur could not have issued the certificate only on the basis of record. Gaur could have issued the certificate only on the basis of record maintained in his office. Even though he issued my lord certificate, he should issue my lord certificate on the basis of record maintained by him. There is no record brought by the Gaur in this case.
Read the records of, read the cross of the Gaura.
Yes. My lord.
Do you have with you?
No, my lord. The cross part is there, my lord. I have.
Crosses you have?
No, I don't have it. It's there, my lord.
Sharma, bolo. First you read the DW2.
Yes.
DW2 is the officer from the election of.
Yes, he
the
is.
previous case.
Yes, I have read it, my lord. He has clearly said there is no documents of 1971 voter
The
list.
previous one.
Yes. May I read, my lord?
Yes, please. Read slowly so that
Yes, sir.
he need not remove the part.
OPW2, Sri Ramani Sharma on oath. মই নিৰ্বাচনী বিষয়া নলবাৰী মহোদয়ৰ নিৰ্দেশ মৰ্মে তেওঁৰ অথৰাইজ ব্যক্তি হিচাপে আদালতত সাক্ষী দিবলৈ আহিছো। 1970, 1977 আৰু 1990 চনৰ বাৰামাৰা, সভামাৰী আৰু 3 নং বৰতলা গাঁৱৰ ভোটাৰ তালিকা আমাৰ অফিচত নাই। মই 2010 আৰু 2016 চনৰ 3 নং বৰতলা গাঁৱৰ ভোটাৰ তালিকা লগত আনিছো। 2010 চনৰ ভোটাৰ তালিকাৰ ক্ৰমিক নং ইমান, ঘৰ নং ইমান, খণ্ড নং ইমান, গাঁও 3 নং বৰতলা ষাঠি নং বৰক্ষেত্ৰী সমষ্টিত বদৰ আলী পিতা মনু বয়স 58 নাম আৰু ক্ৰমিক নম্বৰ ইমানত ৰহম আলী পিতা বদৰৰ নাম অন্তৰ্ভুক্ত আছে 2016 yes
Which village?
মাইলত 58 নামত ক্ৰমিক নং ইমান ৰহম আলী আৰু পিতা বদৰৰ নাম অন্তৰ্ভুক্ত আছে 2010 চনৰ ভোটাৰ তালিকাৰ ক্ৰমিক নং ইমান মৰ নং ইমান খণ্ড নং ইমান
Which year? Voter Telika?
2010 মাইলত
2010.
10
Which
3 নং বৰতলা
3 number? Fine.
3 নং বৰতলা 2016 চনৰ 60 নং বৰক্ষেত্ৰী সমষ্টিৰ 3 নং বৰতলা গাঁৱৰ ভোটাৰ তালিকাৰ ক্ৰমিক নং ইমান ঘৰ নং ইমান খণ্ড নং ইমানত বদৰুদ্দিন পিতা মনুৰুদ্দিন আৰু ক্ৰমিক নং 1793 ৰহম আলী পিতা বদৰুদ্দিনৰ নাম অন্তৰ্ভুক্ত আছে ৰহম আলীৰ নামৰ বিপৰীতে ৰঙা চিয়াহীৰে দি হাতেৰে লিখা আছে that is the cross part of the melody
Ramani Sharma, the
Ramani Sharma.
authorized officer from the election
Yes,
of Tirunelveli district. Then
second one is
the Profullo Talukdar.
Pranab Kumar Taluk
Pranav Kumar.
Profullo Mojumdar no sorry Profullo Mojumdar it is Profullo Mojumdar son of so-and-so Hindu aged about 55 years I resided in Nong Bortola police station Mukalmur Nalbari on মই ৰহম আলীক চিনি পাওঁ মোৰ লাটৰ মানুহ ৰহম আলী সৰুৰে পৰা দেখি আহিছো ৰহমৰ দেউতাক বদৰুদ্দিনক চিনি পাওঁ মই ৰহমৰ দেউতাক বদৰুদ্দিন আৰু ৰহমৰ নামত দুখন প্ৰমাণপত্ৰ দিয়াটো সঁচা প্ৰদত্ত 7 আৰু প্ৰদত্ত 7A বদৰুদ্দিনৰ দেউতাক মনা মিস্ত্ৰী আৰু মনুৰুদ্দিন বুলি জনাজাত আছিল ভোটাৰ তালিকা চাই প্ৰমাণপত্ৰ দিছো মনুৰুদ্দিনক মই লগ পাইছিলো প্ৰমাণপত্ৰ দুখনত থকা চহীটো মোক এই গোচৰৰ তদন্তকাৰী বিষয়ে সোধপোছ কৰি জবানবন্দী হোৱা নাই মোৰ উপস্থিতিত ৰহম আলীৰ পৰা তদন্তকাৰী বিষয়ে কোনো কাগজ বিচৰা নাই মোৰ নামত তদন্তকাৰী বিষয়াই যি জবানবন্দী গোচৰত দিছে সি মিছা ৰহম আৰু ৰহমৰ দেউতাক বদৰুদ্দিন বৰ্তমান জীৱিত মোৰ তাত যি চৰকাৰী নথি আছে তাত ৰহম আৰু বদৰুদ্দিনৰ নাম আছে মোৰ মতে ৰহম আৰু বদৰুদ্দিন ভাৰতীয় নাগৰিক বাংলাদেশৰ পৰা অহা মানুহ নহয়
These are from knowledge.
yes মোৰ মতে
Then
ক্ৰছ মেটাৰ মোৰ আৰু ৰহমৰ ঘৰৰ দূৰত্ব প্ৰায় 1-2 কিলোমিটাৰ বদৰুদ্দিনৰ ভাই ককাই 3 জন বদৰুদ্দিন চাহাৰব আলী আৰু হজৰত আলী বদৰুদ্দিনৰ ল'ৰা দুজন তেওঁলোক ৰহম বৰহান ছোৱালী কেইজনীৰ নাম নাজানো সত্য নহয় যে তদন্তকাৰী বিষয়াই ৰহম আলীৰ বিষয়ে সোধপোছ কৰি জবানবন্দী লৈছিল মই তেওঁৰ জন্ম অসমত হোৱা বাবে তেওঁক ভাৰতীয় নাগৰিক বুলি কৈছো that is by the গাঁওবুঢ়া madam So whatever deposed by the Gaubura on his personal knowledge and
the voter list of 2000.
voter list of on the basis of some voter list melody. And he has not produced any documents record before the tribunal. So first of all, that Gaubura is not authorized to issue a certificate. That is 1 point, my lord. Even though he has to prove it on the basis of contemporaneous record, my lord. So both these aspects were not considered by the tribunal while my lord considering the passing the opinion. Another issue, my lord, my lord, the Gaobra has come. Suppose we accept that Gaobra's evidence can be accepted as oral evidence.
No.
Suppose
You're
we-
relying on these three judgments?
Yes, my lord, these three judgments. And
If you have anything,
My
put
lord.
it on Friday in a written argument.
yes,
Right?
some aspects, my lord, because
Give us 1 by 2, 1, 2, 3, 4. We'll
yes, yes,
Yes. It is basically, you see, the exhibit 1 that we have just now.
Mallet.
That NRC document also is not tenable in law. It's not an evidence for the purpose of, that is law laid down by the long back.
Mallet.
That is also in 1970. So that is one. Secondly, the voter list that we have been seeing
Mallet.
is 70 and 77 voter lists are not available as been stated by
In the
the,
office.
that's not proof. In
Mallet.
fact, those are not exhibited also.
Mallet.
Those were not exhibited documents before the tribunal. After the NRC document issued by the, give us the original.
My lord,
Will come to just
Mallet,
to
Mallet,
clarify.
Mallet.
That is the reason we want to know from you.
Mallet.
The first exhibit is the NRC document. As you have also said, it has been issued by the Kamrup District Jamiyat Ulema Hind. And that cannot be considered as a piece of valid document or reliable evidence for the purpose of nationality. Then the 71 voter list not been exhibited, 77 voter list not exhibited. And ultimately, it was the voter list of 2019.
90, 70 and 75.
Yeah.
85 is
The
there.
third exhibit 3, that is 1997 voter list.
Right.
1997 voter list to number 1 Bortola village. You can note it down, number 1 Bortola village, where one Bodor Ali, son of Mona, and Fulmala Begum, wife of Borod, has been reflected. This is relating to 1 number Bortola and 2 number Kaplabari, Kaplaburi
Let me
of 1997. This is the certified copy you have said, but this certified copy is again not in pursuance to the section 76 of the Evidence Act. Because the name of the concerned officer who is authorized to issue that certified copy has to be there. It is not there. The date of signing that thing should be there. It is not there. It's the date of the concerned officer is not there. Only the initial is there. Then the next voter list was of 2006. That relates to number 3 Bortola, where name of one Bodor Ali, son of Mono, and Raham Ali, son of Bodar, is there. But the Raham Ali, for the first time, his name figured in the voter list in the year 2006 with age 28. Right?
Right.
So 2006, in fact, 7 years prior to that, the voting age has was become 18 years. For the first time, the name of Raham Ali figured in the voter list, in the voter list of 2006, is at about 28 years. That is with regard to number 3 Bortola. Then the next voter list is of 2014. That relates to number 1 and number 2 Kaplavari. Number 1 and number 2 Kaplavari. Nothing to do. 3, number 3 Bortola. We can have number 3 Bortola. We can include it. In the EPIC card, that is the exhibit 6, the voter card of the petitioner specifically mentioned his village is number 2 Kaplabari. Then the exhibit 7, the certificate issued by the village headman of number 3 and 4 Lat of Bortola village. 7A is related to the petitioner. Right? Then the PAN card of the petitioner.
My lord.
Tell us, these are the documents on the basis of which the
My lord.
tribunal considered it,
My
where
lord.
these things are not to be accepted as reliable evidence.
My lord, great grandfather to the petitioner, my lord. In between his grandfather, father, and the petitioner, all are the Indian citizen. That's because, my lord, the great grandfather purchased a plot of land in the year 1950, my lord, and exhibit 9. Purchased on 12/1/2000, sorry,
How we have
12/1,
proved that document?
1950.
How we have proved that document?
And thereafter, my lord, there are 3 numbers of revenue receipt dated 9/11/2000,
That's right.
1967.
How you have proved that document? That's what we want to know from you. You are required to prove that document, right? How you have proved that?
My lord, DW1 has been exhibited in this and proved in original also in all these documents, my lord.
Proved in original?
My lord. When the judgment, it will take time, my lord. Through judgment, I have to submit, my lord. So, my lord, fixed another date, otherwise, no, my lord.
You submit your written argument by Friday.
My lord, on Friday, I will not be available at Guwahati, my lord. My daughter yet Dibrugarh, my lord, so I have to go to Dibrugarh. So, after vacation, it may be fixed, my lord, I will submit the written argument.
You submit your written argument on 19th. 19th.
19. Okay. 19, no. But it may be end of January.
For written argument, you need not need so much time.
Well, I have, I will not be, I'll be busy in another, in the vacation period, my lord, I will not be able. That is why, my to prove the linkage, my lord, the voter list, my lord, to 2006, 2010, 2014, 2016 are there, my lord, along with the parents, the proceedings casted the vote. So, my lord, I will.
What is your registered children?
My lord,
What is your registered children?
is dated my lord 12/1/1950, my lord. 12/1/1950. Exhibit means 9, my lord.
Exhibit
Exhibit 9,
9 or 11?
9, my lord. Exhibit 10A to 10E are the revenue receipt. You got it? Another state document. Document profile is there. 11 paper, other than the state document. Not for 9. I mean, it is done another way.
Exhibit 10, you are saying?
9.
It's 9.
No, no. Exhibit 9. 9, 9.
It is not registered. It is not registered.
Registered one. Registered.
Who sold it?
Well, on a written argument, I will submit my lord on that. I will explain fairly.
Crown correct. Need a zero. Stamp put 1950. Can there be the queen in the 1950 in the stamp paper? You said that it was exhibited in, it was sold in 1950, right? In a
Yeah.
stamp paper, can there be queen?
How that also process,
How can there be queen in the 1950?
my lord, from the judgment, I am submitting, my lord.
We are asking you.
My lord.
You have executed, we don't know. You can show us the original. There cannot be a queen
Original exhibit.
in the stamp paper in 1950.
Hmm.
That itself reflects something else. You know the name of the flag of United Kingdom? It's called Union Jack. And Union Jack was brought down the midnight of 1947, 15 August. So after that, there cannot be any queen in the stamp paper. list on 19th, enabling both the petitioner.
My lord, it may be listed on, my lord, 30th of January, my lord.
Why?
It will take time, my lord. I have to, after vacation, I will prepare.
That cannot be. It will be on 19th. See later. Enabling both counsel for the petitioner as well as the respondent. One is there. Written argument.
Yeah, 19th.
19th of January.
My lord.
It will be like it.